Lieutenant Ron Ball of the Rexburg Police Department.
Good afternoon, Mr. Ball. And Mr. Means, this is Ms. VALLOW with you, Ms. Daybell.
Correct, Your Honor.
Good afternoon, Ms. Daybell. We have a number of preliminary matters to address, so I ask for your patience while we go through those. First, I will note that we are all wearing masks in this courtroom. Today, pursuant to the Idaho Supreme Court's order regarding the COVID-19 virus, everyone in Idaho will begin resuming court business after a lengthy hiatus due to the virus, and we will all be wearing masks. It will take some getting used to. The courtroom deputies here are also going to make sure that social distancing is enforced. I have previously made findings on the record that allow us to hold this hearing in person. That's also required under the Supreme Court order, as most hearings are being held remotely by their order. This hearing is being live streamed and can be viewed on the Madison County Sheriff's Facebook page as well as eastidahonews.com. Today, we are here for a bond reduction hearing. A previous bond reduction hearing was held in early March. At that time, Judge Edens reduced Ms. Daybell's bond to $1 million. I have not been asked to review Judge Edens' sound decision and will not do so today. Mr. Means filed a motion to reduce bond on March 24th and another one on April 2nd. The one on April 2nd was supported by his declaration. This hearing today was previously set on April 17th and April 24th. But those hearings had to be vacated and reset because of the Supreme Court's order regarding the coronavirus, when only emergency hearings were being held. The hearing was set for today, which is the first day that the Supreme Court order allows Idaho courts to start doing non-emergency business. As noted, I have not been asked to review Judge Edens' decision. What I have been asked to do is reduce bond on Mr. Means' allegation that new facts have come to light. In summary, Mr. Means alleges that he is being given an inadequate opportunity to communicate confidentially with his client at the jail. The state has objected to both the bond reduction and the allegation that Mr. Means and Ms. Daybell are unable to privately communicate at the jail. That objection by the state is supported by the affidavits of Lieutenants Ron Ball and Jared Wilmore of the Madison County Sheriff's Office. All right, Idaho Criminal Rule 46L2 is the standard that I must apply to my decision here today on this motion, and it states the court may reduce the existing bail if the court finds good cause to reduce the bail of the defendant. The court may enter such an order reducing bail. So good cause is the applicable standard to my decision today. It's very hard to breathe with the mask on, Justice Burdick. I will also note that shortly after receiving Mr. Means' motion alleging problems communicating with his client at the jail, I held an informal status conference with Mr. Means, Mr. Wood, and a representative from the jail. The purpose of the status conference was to quickly ensure that Mr. Means was able to adequately and privately communicate with his client while the jail was trying to implement procedures to protect the inmates from the COVID virus. I also wanted to make sure that Mr. Means had an opportunity to connect with jail personnel so he knew how to communicate with them directly to resolve any problems that might arise. All right, I have read all of the motions, the objections, declarations, and affidavits filed in regards to this hearing today. Mr. Wood, are there any preliminary matters you need to take up?
No, Your Honor.
And do you intend to call any witnesses today?
I don't believe I will need to, Your Honor.
You're relying on the affidavits that have been filed?
Yes.
All right. Mr. Means, any preliminary matters?
I do have a couple, Your Honor.
Go ahead.
Okay, thank you. One of them is, a couple of them are going to be well, and if you don't mind, I'll remain seated unless you prefer me standing.
In the 7th District, we have attorneys stand when they make arguments to the judge.
I'm sorry, I can hear you, Your Honor.
If you would stand, that's
Sure.
our custom here in the 7th.
No problem. I was told there was yeah, I can do it here. It'll be fine. Your Honor, I've got a motion to strike the pleadings that were filed yesterday at 2:42 in the PM, about 18 or so minutes before our 3 o'clock scheduling conference yesterday. As the court noted that this motion has been on the file since the end of March and has been noticed repeatedly by the court as a result of the COVID-19 process. The prosecution cannot claim that they had any kind of lack of notice or any kind of deadline or response needed in this case. When you look at the filings, you have a total of 18 pages. 10 of those pages are single-space affidavits that were filed yesterday. Again, sent over a little before 3 o'clock. Council's well aware that I don't live here locally. Trying to address or respond to new arguments, new affidavits filed literally less than 24 hours before today's hearing makes it extremely difficult for me as an attorney and is extremely unnecessarily prejudicial to my client in trying to respond to these new affidavits. Again, this is not an emergency motion that was set by the court yesterday. This is a motion that's been filed since March. And as I get into the arguments with the motion, I think the prosecution will admit why the initial motion was filed and was ultimately necessary. We've worked hard to have the information communicated to the court in a timely manner. Here, we have specifically an objection that raises whole new arguments that were not mentioned in the previous objection filed back on the 7th of April. We have case law that was not cited back in the initial filings in April, on April 7th. We have 2 affidavits from individuals that, again, are single-space, total of 18 pages, that were not mentioned in the previous filings. The rules on a motion such as this is that you have to file any document that needs to be served in a timely manner. The day before the hearing is extremely prejudicial. It makes it extremely difficult for me to file a response. I don't have an opportunity to investigate these affidavits. I don't have an opportunity to have responsive affidavits. I don't have an opportunity to research the case law that is cited now by the prosecution, and there's no credible reason why they would be filed so late. In fact, there's a pattern here that we've seen. As the court mentioned before, we had an informal status conference regarding my motion when I filed it back in the end of March. If the court will look at the repository history filed with this case, about 2 hours before that hearing, after my motion had been pending for 13 days, the prosecution files their initial response. Again, I'm out of state. I'm working out of the office. We have the COVID issues going on. And less than 2 hours before that hearing, they filed their response. I don't know if we're going into this informal hearing to discuss the motion or to discuss resolution. I don't really have an opportunity to respond. We see that again here today, and it's completely unnecessary and extremely prejudicial to my client. Now we look further into the affidavits and the briefing. Again, new case law. We see new accusations. We see that the prosecution has had access to records that have been subpoenaed and requested through discovery that are presented in these things that yet have not been produced as far as statements goes and allegations of when things happened. We also have other violations besides it being untimely and suspect as to why it was untimely. We have violations such as the affidavits. Any affidavits or any pleadings filed with the court have to be double-spaced. These are single-spaced. Again, they cram a lot of information into you, and if you need a rule on that, It is Criminal Rule 2.3A5. And earlier I made reference to the motion hearing. This is our motion, which is governed by the Idaho Criminal Rule 49. In Rule 49, it states that the time for filings is governed by the Idaho Civil Rules of Civil Procedure, which would be Idaho Rule Civil Procedure number 7. Number 7 requires that if you're going to file a responsive affidavit or memorandum or brief, you have to do such 7 days in advance. I'm all for emergency situations, especially with what we're dealing with. I'm all for the idea that sometimes things just can't get done timely. This motion has been pending since its initial filing for 39 days. There are no surprises there. My second amended motion, providing more detail to the court, was filed 28 days ago. They were on notice that we had alleged that they were recording our conversations for the past 28 days. But they filed their memorandum and they filed their brief and their affidavits literally less than 24 hours before. So what I'd ask, Judge, is that the 2 affidavits and the brief that was filed yesterday be stricken from the record.
Mr. Wood, your response?
Yes, Your Honor, the rule he cites doesn't require me to do that. I'm not required to file that in any time before that. I am allowed to file that at any time prior to the hearing. I'd note, Your Honor, I'm not even required to file anything. I don't even have to file an objection. I can just show up and object to a motion to reduce bail. I'm not required to do that. And so the fact that the affidavits are single-spaced, I would say, well, there's no harm, Your Honor. He's got to show some harm to that issue. As far as the issue of the filing, I don't see any rule that requires a time on that. So unless he can further articulate a rule, I think that motion needs to be denied, Your Honor.
Your Honor, let me respond. Idaho Criminal Rule 49 states that anything that is required as far as pleadings that need to be served have to be filed pursuant to Idaho Criminal Rule of Civil Procedure 7. 7 outlines that any briefs, affidavits, or responsive pleadings have to be filed 7 days in advance of the hearing. Obviously, it's not 7 days. And the way it's articulated to the court is, if he wants to show up and object to the hearing or object to the motion, fine. But there's a difference between objecting and filing briefs and affidavits less than 24 hours before. In the single space, unfortunately, no, that's not an accurate reading of a rule. I do not have to show to the court damage or prejudice to my client as a result of a violation of a rule. That's not the way the rules work. They have specific limitations on the format of what these documents are supposed to be because there's a limit to how many pages can be filed. Here, you take an 8-page affidavit, single space. If you space that out, we're over the 10 pages. There's intent there to circumvent around the rule here and try to cram more information in less than 24 hours and or statements to this court and not give an opportunity for my client to respond. Extremely prejudicial, extremely untimely, extremely unnecessary. 38 days, 28 days, the other side have had notice of this motion.
Mr. Means, can you point to a rule that says that Mr. Wood has to give you notice before calling witnesses at this proceeding?
Yeah, I will, Your Honor. So this is our motion. It's a motion for a bond reduction hearing. And that was, if Mr. Wood has consented that, or stated to the court that he's not intending to call witnesses, I don't know if necessarily we have to go down this road or not. If he is intending, 1, if the witness is in the room, I'd ask that they obviously be excused. 2, that was my next motion that I was going to make regarding a strike or a limitation is, this is defendant's motion. Again, filed 38 days ago, pursuant to Idaho Criminal Rule 49, with the supporting cites to statutes and whatnot. This is a motion. It is not an evidentiary hearing. At no point in time did I request, express or imply to the court to make this an evidentiary hearing. We asked for a motion hearing. Idaho Criminal Rule 49 describes how you respond in these type of motions. You have your motion, and if you want to, you file an affidavit. And then the motion is argued on the affidavit. There's a little flexibility with the oral arguments when you're discussing the various affidavits that are, of course, filed timely. There is no expression in the rule that discusses how you mutate a motion hearing into an evidentiary hearing. And if we go back and we look at even the notices of the court, for all of these hearings, it is noticed and entitled Motion for a Bond Reduction Hearing. At no point in time was there any kind of notice, at no point in time was there any kind of request that there was going to be additional evidence or additional persons or witnesses testifying. Again, extremely prejudicial. We've had this on the calendar for over 30 days. If they were going to call someone, they should have provided notice. Now, it sounds like this is not an issue, but again, this is our motion. If they wanted an evidentiary hearing 30 days ago, 21 days ago, 14 days ago, they could have filed a motion asking for an evidentiary hearing to be heard simultaneously with this motion on a bond reduction hearing. They didn't file anything other than their initial objection back on the 7th of April, and then yesterday, 18 additional pages. So what we would ask is that the court not allow this motion hearing that is governed by affidavits be changed into an evidentiary hearing where things we have no idea might be presented and no opportunity to respond. And again, completely unnecessary.
What rule do you refer to, Mr. Means, that says that this can't be an evidentiary hearing?
I
Or
think
that it is or is not, or that affidavits are relied upon?
Sure. I don't know if there's a specific rule that says it can, but I'm not aware of a rule that says it can. And so we came under our motion, and our motion only requests oral arguments. It's notice.
What I'm wondering is, because you request oral argument, I'm looking for a rule or something that says that Mr. Wood can't respond with testimony. Because that escapes me. I mean.
That he can. I guess is my position. And the way it's noticed from the court is that it's a motion hearing. And in Rule 49, it talks about filing your motion. And basically, if you want, file an affidavit. There is no mention of the mutation into an evidentiary hearing without.
Where's the rule about affidavits that you're referring to?
I don't know Rule 49. It's very short and it's very straightforward.
I don't know. 49,
Yes.
which section?
Yes, ma'am. There's only one section. Let me see if I.
I'm looking at Idaho rules 49, A through D.
Let me see. Oh, excuse me, Idaho Rule 47. There's 3 subsections, A through C.
All right, so it says a motion may be supported by an affidavit.
Exactly, maybe. You don't have to, like the prosecution said, he could come in and object to our affidavit, and that's completely right. But I think he's limited, given the rules of what kind of objection he can give, because.
That's where I'm having the sticking point, Mr. Means. I'm not at all following your reasoning on why he can't respond with affidavits or testimony or witnesses or in any other fashion.
Sure. When I look at Rule 47, there's no mention of any kind of evidentiary proceeding or live testimony that's offered to the court. What it says is, a motion, except when made at trial or hearing, must be in writing unless the court permits the party to make the motion by other means. A motion must state the grounds on which it is based and for relief or order sought. A motion may be supported by affidavit. There's nothing in the rule that says the day of the motion, the other side is allowed to present extreme amounts of information or new arguments or new testimony or new affidavits. It says that.
I've read the rule.
Sure.
So what your argument, you're saying that even with the motion to suppress, the state couldn't call witnesses?
Well, not because this is our motion. My argument is, we noticed this up as a motion for a bond reduction hearing. At the previous bond reduction hearing, there was no request whatsoever for any kind of testimony, additional evidence. There was arguments given. We noticed this up to be very similar to that in a motion. They had an opportunity, if they wanted to have a motion for evidence, if they wanted to have live testimony, in any of these 38 days, they could have filed a motion to have it heard simultaneously today. So if you look at it, or even before or subject to the court schedule. So if they're allowed to file midnight affidavits totaling 18 pages in violation of the format rules and these other rules, it's unnecessarily extremely prejudicial to my client. Now, we can address them if we need to, but I have, and I hope I articulated this, 2 motions to strike. 1, the affidavits and the briefs that were filed, and 2, any witness or any other evidence that wasn't prior noticed or provided over to us at any time. No mention, no notice filed with the court of the intent to call witnesses, no kind of notice. This is extremely prejudicial. I'm not a fan of, if that was allowed, of an ambush type tactic when you're practicing law. I think it is wasteful of the resources that this court puts together to conduct a motion like this, to engage in those type of tactics.
Well, motions to suppress are filed by the defense, correct? So by your reasoning, the state could not have put on any testimony of that without notice first.
Without some kind of notice, or either their own motion asking for an evidentiary hearing. Because again, we only asked for a motion and affidavit oral argument. This is our motion. We didn't ask for anything else.
All right.
Your Honor.
If I may. This is a bond hearing. The state's response was in direct response to the motion and the declaration filed by the defense. We are pre-preliminary hearing. It's simply a bond argument. Again, a reasonable time to respond. I responded yesterday. I informed the court and counsel so they had time to read it. It's not like I filed massive treatises on bail reductions. I filed 2 affidavits and a response. And the reason, quite frankly, why the defense is arguing so vociferously to this is because they've been caught filing misleading statements to the court. And so, Your Honor, every day defendants are charged with felonies and have bond reductions without any notice to the state or any notice to anyone. There is no requirement, and he has failed to articulate any requirement that I had filed this any earlier than I did. It was in a reasonable time. And so, Your Honor, I ask the state to deny this motion. I think it's without merit entirely.
Thank you. Well, Mr. Means, what I will say is that in my many years of practicing in criminal courts in eastern Idaho, I've never heard your argument, and I've never seen that in practice. That someone has to give evidence that they're going to, or has to file notice that they're going to call witnesses or put on evidence at a hearing at this stage of the proceedings. Only at trial have I ever seen that enforced. And in fact, in the motions to suppress that I've been a part of, the defendant files the motion to suppress and the state shows up with whichever witnesses they think will support overcoming that motion without any notice whatsoever. So that's certainly the practice in East Idaho, is to not give any notice and to just put on evidence when these motions are made. So I'll give you a couple of options here. Which is what I usually do in civil court, where I usually hear these sorts of motions to strike affidavits. And that is, we can go forward today, or we can reset the hearing so that you have sufficient time to review the affidavits and respond to them.
We want to go forward today, Your Honor.
All right.
A few of the comments were made that I think need to be addressed prior to making your final ruling. I understand you're making a ruling on this motion, but a few of the things were said. Specifically, this isn't the state's initial response. This is a second response, right? And so I guess what the state is arguing, and I just want to make sure I understand this, that less than 23 hours before, or give or take 23 hours before a hearing, filing 18 pages, a second response with new case law statements, new persons, all of these things prior to the hearing today, according to the state, is reasonable, timely filing for today. The argument that the defense is engaged in any kind of misrepresentation is, we can get into this in a little bit, but it's disgusting. It really is. And the affidavits admitted I would argue that if I were the prosecution, I would not want them admitted once we go through kind of the history here, but I'm getting ahead of myself. It's just that statement was thrown out, and I think it needed to be addressed, Your Honor.
Your Honor, I would just point out that the
Court has no requirement to make the finding he just asked the court to make.
All right, Mr. Wood beat me to the punch that I don't have to make any findings. I've given you the choice of whether or not you want to continue this proceeding so you can better respond to the affidavits, or if you want to go ahead today on the affidavits, or if you want to require Mr. Wood to call witnesses, because there's nothing in the rules that prevents him from calling a witness at a hearing such as this. So I leave that choice up to you.
We can move forward, Your Honor, and I do have one other preliminary matter.
All right, then I will accept your request to go forward today in spite of your objection and motion to strike. I'm denying the motion to strike based on your choice. What was your other preliminary matter?
In the initial filing, objection to our motion, Your Honor, filed back in 4/7/20, in paragraph 2, there's a reference to what is entitled as a valid order. It's a slippery slope type situation with this paragraph.
Are you talking about the affidavit that Rob Wood filed on April 8th, or which one are you referring to?
No, Your Honor, his initial objection to our motion to reduce bond, it was filed, I believe, on the 7th of April.
All right,
It's got 8 paragraphs.
okay, I see it.
It was the one that was filed right before that informal hearing that you brought up. Paragraph 2
Okay,
references a valid order. Now, I think, without getting too far, there are 3 currently pending actions here in Madison County involving my client. You have this case, you have the guardianship case, and you have a sealed case, okay? In the sealed case, this is the difficulty that I have. It is not appropriate to bring up the things that are being filed or alleged or whatnot in a sealed case in a public forum such as this. But in paragraph 2, he references the order. Now, we're dealing with alleged contempts regarding this alleged valid order. And with this valid order, in this case, we have count 5 of the complaint that seeks that she be held in contempt with a maximum for disobeying this order, and with a maximum sentence of 6 months and a $1,000 fine. In paragraph 2, he's referencing an indefinite suspension be held until you are coerced into complying with this order. The problem that I have in responding to this is that is the remedy, and again, I'm hesitant to bring this up, but that is the remedy that they are seeking in the sealed case. It is not relevant to this case here, where the contempt that they're seeking to have her found guilty of is at a maximum 6 months and $1,000. So I want to strike that portion of paragraph 2 in reference to the requested remedy from the court and the reference to the valid order, because it's in direct correlation with a sealed action. If it is not stricken, I think we all take the chance of slipping down the slope of discussing potential things in a sealed action, where really the value of paragraph 2 versus the risk and the prejudice and the violation of a sealed order isn't worth going that direction.
well, isn't it also directly relevant to count 5
Well,
of this complaint?
Somewhat. The maximum amount of sentence in count 5 is 6 months and $1,000 fine. He cannot turn around and ask, with my client not being found guilty, I mean, we cannot put obviously aside that she is innocent until proven otherwise. Regardless of the contempt, regardless of the pending order, there are various defenses that a person can present to the court that would negate an allegation of not complying with an order. Those are all in play. He's asking for my client to be held indefinitely incarcerated until she complies with this order. This order is referenced to count 5, which again, the maximum sentence is 6 months and $1,000. So if he wants to amend paragraph 2 to mean, hey, hold her until 6 months and $1,000 fine, that's fine. That would be a more relevant argument for today. But to ask for an indefinite incarceration to lead to a coerced alleged obedience to an alleged valid order in reference to a pending sealed action, I think is a little difficult for my client to respond. And the value versus the prejudice, the value versus potentially violating a sealed order and the conduct that comes with a sealed order is tremendous, and it's not necessary.
All right, well, I am not in the habit of striking other sides' arguments, so I'm going to deny the motion to strike paragraph 2 because that is an argument in objection to your motion. And further,
Your Honor, there is something that needs to be pointed out for the record.
let me finish, Mr.
Oh,
Moore.
I apologize.
Further, it references the count 5 of the complaint in this case. I'm not sure what the penalty has to do with this. I understand that you're saying that she be held, I understand your argument that you're saying Mr. Wood is arguing that in paragraph 2, his argument is that she should be held indefinitely. That is not the way I see his argument at all. You filed a motion for bond reduction. He objected to that, saying that she's still in violation of what he alleges is contempt in paragraph 5, and that he doesn't want the bond reduced. It's not Mr. Wood asking for her to be held indefinitely. It's his objection to her being released on this motion today. Now, Mr. Wood, anything you'd like to say?
Yes, and I do apologize to the court for interrupting. It should be pointed out on the record that that court order is not sealed. That court order was specifically unsealed. And so I think that's very important because otherwise it sounds like we're talking about a sealed matter. We're not. The existence of that child protection action by order of the court was made public, and the existence of the court order that she produced her children was public. And other than that, I think the court has correctly stated what the state was asking for in that objection.
All right, thank you. Anything else preliminarily, Mr. Means? If not, you can go ahead with your argument.
No, Your Honor, I'm just looking at paragraph 2 and its reference to the Child Protection Act. Obviously, we'll just put on the record that any conversation regarding sealed action, we're at standing objection at this point.
I appreciate that, and I appreciate Mr. Wood pointing out that that order and the fact of the case is not currently sealed, and I am sure he will not mention any part of that case that is sealed, and we'll hold him to that. So go ahead, Mr. Means.
Thank you, Your Honor. My argument, I think, most likely makes organizational sense if I present it in the way of the initial filing by the prosecution on 4-7, where they list the eight paragraphs there. The first objection is that they disqualify, alleging that because we disqualified the previous judge, that we're attempting to take a second bite at the apple. That's obviously not true. Our motion alleges new evidence has come to light, needs to be discussed with the court that should be considered in setting bond for my client. There is no implication that because we've got a new driver in the seat that we want to take another bite at the apple. Number 2, obviously we discussed that issue. Paragraph 3 and 4 of his argument discusses limitations on access to a client as a result of COVID-19. Now, I'm sure the court is aware that across the country, challenges to stay-at-home orders and these other type of things are rising quite often because of the unique situation that we're in. Going back and trying to find case law on something like this, and I think you're going back to the early 1900s to find something similar to what we're dealing with here. But I think the Attorney General, William Barr, hit it on the head when he sent out a memo, and it was basically a notice to state and local ordinances and officials that, hey, we understand there's some difficulties here.
Are you saying that the federal government has authority over the state government?
No, Your Honor, I'm just saying his point is well taken, and the wording is probably better than I could articulate to the court. And so what he says is, if a state or local ordinance crosses the line from an appropriate exercise of authority to stop the spread of COVID-19 into an overbearing infringement of constitutional and statutory protections, the Department of Justice may have an obligation to address the overreach in federal court. Barr continued to say that any restrictions on religious liberties, discrimination against disfavored speech, and undue interference violate federal laws. We do not want to unduly interfere with the important effects of state and local officials to protect the public. But the Constitution, and this is my point, is not to be suspended in a time of crisis. My point there is the rights of my client as far as Article 6 and any other pending or applicable article or amendment here, as well as the due process rights, are not to be suspended as a result of the situation or circumstances that we deal with. Now, I think the gray area obviously is where does a local or state government overstep where it interferes with the Constitution? And that's where, we are today. I want to go back here a little bit. The court referenced my original motion filed toward the end of March on 3/24. If the court will recall, there was a previous motion bond argument on the 6th. After the 6th, I returned home to Boise to come back here to Rexburg on that following Monday, and I stayed for 4 days working with my client. One of the reasons why I did that, and we spent approximately 15 to 20 hours probably over the course of those 4 days going through the case, going through the accusations, going through the history. It is not a simple case when it comes to the amount of players and the accusations and the innuendos and all of these type of things. And so it took quite a bit of time in order to do that. I felt that was necessary. I felt like I needed to be there. That communication prior to coming over on the 9th, or that after that bond hearing, was conducted over the phone, and it was also conducted in person. Now, I had set up prior to conversations with the prosecution, conversations with various deputies down at the detention center, where we had conversations about my need to have a confidential access phone line to my client. They instructed me to call the detention center, tell them who I was, and then I would be transferred to a line where my client didn't have to put in a code, it wasn't recorded, and I would have this access to them. We discussed incredibly sensitive things. Now, if we fast forward from that point to where we are now, as you'll
What date you're talking about that occurred?
well, that would have been the 9th, I believe, through and I have it in my argument here a little bit, and I'll clarify it. The 9th through the 12th. I believe it was a Monday, Sunday through a Thursday. Okay, that I was back over here. Now, I think what caused the ruckus here is during that time, I had various conversations with my clients and a visit with the prosecution in this case. Now, if we can jump forward to my amended motion, and I'll come back to this. In my amended motion, I show up here on, what is the date? Give me 1 second, Your Honor, I just lost my date here. On 3/29, I come back over here to the state of Idaho to visit with my client, assuming I'm going to have access like I had before, in person in a room. There was no notice to me that obviously there was a change in procedures due to the COVID-19 process. I understand that. When I went to the detention center that morning, I made it routine that I would call the detention center and let them know I was coming. I think that is a matter of courtesy, notice, and if something's going on at the detention center that might delay access to my client, no reason for me to sit into the waiting room for quite some time. No problem was expressed. I show up, I go into the waiting room, a deputy comes out. I said, well, I'm Attorney Mark Means, I'm here to see my client, Lori Daybell, please allow me access to my client. I was then instructed that the procedure for visiting with the client had changed, and that the public visiting room had now been converted into an attorney-client visiting room only, and that I would have to converse with my client because of COVID-19 policies through this public now visiting room. I said, well, that I have a box of documents, I have 16 gigabytes of information I need to go through with my client, I need to physically see them. They said, no, you're gonna have to go to this. I said, well, I'm already here, I need to visit with my client. Is it confidential? I was specifically told, multiple times that morning by that deputy that my communication with my client would be confidential and not recorded.
On March 30th?
Yes, Your Honor, they're in the waiting room multiple times. I might not be the most seasoned attorney, but there is absolutely no way that I would ever get on a phone thinking that it was going to be recorded and have incredibly sensitive conversations with my client regarding their defense. They told me that the room had been changed at that point to a attorney-client visitation room only, and that the recordings were not going to happen. When they brought my client in, we sit down and we start having the conversation. I can't recall on that day if I heard the recording statement or not, but I was told repeatedly, asked repeatedly to the deputy, was assured that it wasn't going to be recorded. We had our meeting, I left, I go do some visits, I come back to visit with my client, same thing. I want to make sure that this is not recorded. No, Mr. Means, it is confidential, it is not going to be recorded, the recording services is turned off.
And was that on March 30th and March 31st that you're referring to?
That was over from March 30th, and I believe I was here until April 2nd. And I had multiple visits with the client during that time. Now, obviously, it was incredibly difficult to try to discuss with my client various documents, as the amount of documents are intense. The second set of discovery rolled in this past week, and we're now talking 60, 70 gigabytes of information, thousands of pages. I have to have this access with my client in order to prepare for this defense. So I did what I could while I was here. We had the conversations over the phone. I was repeatedly told it wasn't recorded. It wasn't going to be recorded. The recordings were off. And so I relied upon that representation to have that communication. My gut was, I think they recorded it. I heard beeping on the phone that just, I don't know if it was a cheap landline. I don't know if it bumped my ear, because as I sit there with the ear pinned to my shoulder, typing on a laptop, trying to show documents to my client, it's extremely difficult. So I go back and I file the amended motion before the court, bringing up my belief that I think it was recorded, even though I was told repeatedly on each time I was there that it would not be recorded. So I file that motion. Now, fast forward, the prosecution does not file a response. They do not call me after I file that motion. They do not make contact with me and say, yes, Mr. Means, we accidentally recorded it, but we've deleted it. We've done what we needed to do, or whatever it is that they were going to do as far as handling it. They file a response on the 13th, give or take 2 hours before our informal conference, and they admit in a statement as an agent of the court in their paragraph, and I believe it was paragraph.
I'm looking at the first objection to your amended motion of April 7th. Is that, are you for, you said April 13th, so I'm trying to.
Yes, Your Honor, I'm sorry, it's April 7th. And in that, paragraph 5. The state represents in paragraph 5 to the court that the attorney, that they learned, and this is where it gets unique and these affidavits come into play, that one conversation between the defendant was accidentally recorded, okay? They admitted, this is a filing by an agent to the court on that day, on the 7th before that hearing. Now, it gets a little more dicey since then. We learned of that, and obviously, we notice up to the court, we request a hearing on this motion, it gets kicked down the road multiple times. At no point in time, prior to the filing of this declaration, or excuse me, of this objection, before or after, do I receive any kind of confirmation of what the recording was, how long it lasted, who deleted it, where was it deleted, how was it deleted, who heard it? No communication whatsoever regarding this. Obviously, there's a concern. So now we jump to the end of March, April, when I come back over here and we learn, let's jump back to the initial bond hearing. When I filed my initial motion on 3/24 to amend the bond, I tried to keep it as less inflammatory as possible, especially given the media coverage. So the allegation is that new lights have come to light that the court needs to consider. When the prosecution, the state, and various individuals represent to the court that this is a one-time deal, that is not being honest with the court. After that,
And now you're making accusations that I want to hear facts supporting.
of course. And so what we have here is a conversation between me and the prosecution where they admit that previous recordings of conversation between me and my client occurred and they deleted them. This was before COVID-19. This was told to me directly. And the way it was told to me directly was multiple phone calls. Phone calls were recorded. When we realized it was you, we deleted them. Obviously, that is not a good situation. Now, you can't go and look at these filings and say, well, this recording back in the 1st of April occurred because of COVID-19. Because in some time between, and we have outstanding discovery and subpoenas for these, sometime after the March 6th hearing, when I was having telephone contact with my client, the state, the sheriff's department, whoever it was recording these conversations. And it's my understanding that these recordings automatically get transferred somehow either over to the police department or over to the prosecution. I don't know the exact process, but it was discovered in the prosecutor's office that they were being recorded and allegedly deleted. So that's why the initial filing, the initial motion. Now again, I was trying not to be inflammatory. I was trying not to cause a storm, but this obviously needed to be discussed because it was a concern. We now have multiple recordings and an objection that state that there's only been one recording and it was accidentally recorded and it was deleted. I attempted to give the prosecution multiple opportunities to relay to the court that this has happened before and this is how we handled it. Their response to me is not, yes, court, this happened, we apologize, we've addressed it. They can't come in and say with a straight face that this was a result of COVID-19 and new procedures when all of this happened well before those guidelines, well before anybody was diagnosed with COVID-19 in Madison County, because it happened then. I gave them those opportunities, and their response to me is that I'm a liar if you look at these affidavits and these responses, because I can't pin it down whether it was the 30th or the 31st. Now that's troubling to me, because also in their response, they talk about that it's not procedural, that Madison County doesn't do this. Again, I want to believe that. I want to believe that attorneys are guided by a higher level of ethics that we are concerned with. I know from my own practice, if I'm ever in a situation where an attorney-client privilege is going to be compromised in one way or the other, that if somebody's other party contacts me, I cut off that communication, I call the opposition, I explain to them the situation, and I say, what do you want to do? In this situation, there's a modus operandi here, much like these late filings. I had to go to the prosecutor, and only then did the prosecutor tell me that there were recordings that they were deleted. I had to file a motion with this court alleging that at the end of March, I was being recorded when I was told I wasn't being, and 13 days later, they admit to the recording. At no point in time did I receive any kind of communication or any kind of email or phone call saying, hey, Mark, this happened. What do you want to do with it? And so we have a situation here that makes it to where I cannot, in good faith, get on the phone with my client being detained in the Madison County Detention Center and be confident enough that the conversation will be confidential and we can prepare the defense, especially given the magnitude of this case. Now, the court decided not to strike those affidavits. I think if I were in that position, as a prosecution, I wouldn't want those affidavits filed. First off, there's multiple statements in there, and I could go through them paragraph by paragraph here. Multiple statements of unnecessary hearsay that is not allowed. If we look at first, I think the first one to go through that's most telling is affidavit of Lieutenant Jared Wilmore. Obviously, this was filed yesterday at 2:42. Lieutenant Wilmore is a deputy over the detention center, I think it's ironic that this affidavit is filed the day before. You know, the prosecution can't maintain they didn't have enough time or whatever. This person works obviously near us. Paragraph 6. He goes and he talks about, he says, I have not time to review my telephone notes, but give or take every time that I intended to come to the detention center, I called in advance. This is what I did. I did not have any reason to not believe I did otherwise on three.
I'm looking at paragraph 6 of Wilmore's affidavit, and because that's what you directed me to, so.
Sure, no, this is my procedure. I should have made that more clear.
So you're testifying now?
No, I'm responding to the affidavit that was filed yesterday.
All right.
And so what we have here is, there's an allegation there that they had no notice that I was coming. Every time that I would come down to visit Lori, I would call in advance to make sure they weren't serving dinner or breakfast, or there was something going on that I could have access to her. Paragraph 8, we now have, interesting enough, we have double hearsay comments involving Deputy Wilmore and now Corporal Ryan Walker. What's interesting to me is Corporal Ryan Walker is an employee of the Madison County Detention Center. Why don't we have an affidavit from Corporal Walker? Why do we have, when you have intelligent attorneys on this case that know this is hearsay, Lieutenant Wilmore coming forward saying, allegedly saying what Corporal Walker is saying? Now, I go on to say, I do not have any reason to believe that, I recall the conversation that he's making reference to when I came in on the first morning. He's trying to attempt in an affidavit to represent what that conversation was in a hearsay type situation, unnecessarily so. I remember the conversation asking multiple times, is this going to be recorded? Is this the only option that I have? I need to physically be in the same room with my client, and I was told no repeatedly, and that this was it. So I didn't have another option. If you go to paragraph 9, 10, and 11, same thing. You have Wilmore making statements about Walker, and it goes further to a whole nother level of hearsay to Sergeant Baxton, and then it goes back and forth. Interesting enough, Sergeant, and I believe you pronounce it Baxton, is an employee there at the detention center too, but we don't have an affidavit from them. We have to rely on triple hearsay here. Paragraph 15, again, hearsay, no excuse as to why it's offered. They try to present the idea that that the person there in paragraph 15 isn't aware that an attorney is there to speak with a client and that this is privileged communication. This has got to be at a detention center, almost a daily routine that these people would go through. And they knew me. If you look in their affidavit, they know I'm there to speak with my client, Lori. They know it's intended to be confidential. They know I've asked them repeatedly, is this recorded? No, it's not. Okay, I can rely on this. If you go on to paragraph 16, again, hearsay. In paragraph 17, it references the recorded statement, and that he tries to maintain that we ignored the pre-recorded statement, but he goes on later on in his affidavit, and he's making reference to, he doesn't know if it was the 30th or the 31st. He says he would rely to me that it was turned off on the 30th and that it was going to be off each time. So then I get accused of, I should have known it was recorded, and I know how to turn it off as if there was a button in the room or something on the 31st. I get accused of misrepresentation because my affidavit or my declaration is 30 or 31st or both. Here they have access to these records and they don't do it. Paragraph 21. This is I think, this is where I think I start to have a little trouble with the case and my concern level rises. Prosecutor initially objects on the filing, saying that the state has learned, again, that there was one conversation that was recorded between the defendant and myself. Lieutenant Wilmore now represents to the court that there were multiple conversations recorded. He references phone calls, plural, between the defense counsel and defendant that were recorded.
Okay, show me where it says multiple.
Well,
Says two.
what he
They
said-
say two.
He says phone calls, plural.
Okay,
And
so where in this affidavit are you seeing that there were more than two? Because they're explicit that they know two were recorded, one for 1 minute and one for 28 minutes. So if you're going to stand up and say that there were many more than that, which is what you're leading me to believe, then I need to see in the affidavit that you're referring to where it leads you to believe that there were many phone calls being recorded.
So, forgive me, these are difficult to breathe in. I think the situation is devil's in the details, right? On the 7th, you have an affidavit filed, or a objection filed by an agent of the court that specifically cited and specifically said there was one accidental recording. And now you have Lieutenant Wilmore saying phone calls with an S.
And are you referring to the two, or you're just saying he referred to the two phone calls by referencing multiple phone calls and phone calls? Because phone calls means two.
Sure.
And so what you're arguing very explicitly is that the jail recorded multiple times and that they're admitting to that in the affidavit, and I'm not seeing it. So I'm trying to get you to point out to me what I'm missing in their affidavit.
When I read phone calls, I don't limit it to two. It's plural. And I think,
You're not convincing me on
Sure,
that
sure,
point.
sure.
Because they explicitly say two, and you can't say phone call when they say there were two. So I understand your argument.
Sure.
And what I'm trying to do is find out where in the affidavit you come to the conclusion that there's more than two, because I really do want to be able to nail down your arguments and what they're saying. So
Sure.
if in paragraph 22 or 23, 21, that you're referring to phone calls, if that's your only reference to multiple as opposed to two, then it's probably time to move on. But if you've
Sure.
got something else to point to in that affidavit, then I'm happy to look for it.
I think the problem that I have here is, one, we have our discovery and our subpoena outstanding for all of this information regarding these recordings. Because at this point in time, you have to remember, I've now been told that there were multiple recordings of my conversation with my client after the initial bond hearing. It's not a good situation to be in. I'm also told that those recordings were deleted. Now, I'm going to represent to the court that there were hours of times that I spoke with my client. We discussed detailed facts of this case that are incredibly sensitive. When the state goes in, whether the state or the agent or whomever it is, the agent of the state, and deletes these recordings, I do not have an opportunity to go back and say, oh my gosh, what was on these recordings? I have my notes, I have my history there, I have my memory, but it's concerning. So I'm told after this bond hearing, multiple recordings. Nowhere in any of these filings does the state confess or come forward and say, you know, court, this isn't the first time it happened. It was accidental. There's no explanation whatsoever. In fact, there's a position of how I read it that the defense is playing games. At no point in time would I, as a defense counsel, intend for my conversations to be recorded. So I have statements saying multiple recordings before. I then have a statement that says, oh no, there was only one and it was accidental regarding this exact situation we're talking about back in the April 7th filing by the prosecution. Now yesterday, I get a 8-page single-space affidavit that comes forward and says phone calls. Again, our discovery and our subpoena are outstanding. We are having to rely on this information here that they're giving us. At this point, I'm comfortable in saying there have been multiple phone calls before and after the COVID-19 process or condition or pandemic that has been recorded in violation of my client's rights to have confidential communication, despite my attempts, even before and after the COVID process, to limit the exposure of my client and to have confidential communication that has occurred. And some of these are forthwith and brought forward, and some of them are not. If we go into 22 and 23, I think there are some conflicts. Again, if you look at paragraph 23, he talks about he found it strange, or that he alleges he turned off the recordings on the 30th, doesn't know why it was recorded on the 31st. But again, in the second objection to this case, I get thrown under the bus as if, one, I should know, two, as if I should know how to turn off the recordings, and three, my statement of whether this occurred on the 30th or the 31st, I'm not exactly sure. As we learn here now, it's ongoing. So then we move on to the affidavit. Give me a second, Your Honor, let me find. Of Ron Ball, Lieutenant Ron Ball. This is where I think we have more difficulties. In this affidavit, it's acknowledged by Lieutenant Ron Ball that he had access to these recordings and he listened to them, okay? Now, there's statements in there about when he figured out who he thought it was, he cut it off. I think we have to do some additional discovery, maybe some additional subpoenas on those issues, but we now have recorded phone calls that are taken in violation of my client's rights that have gone from the sheriff's department. We've had recorded phone calls that have gone to the prosecution office. We now have recorded phone calls by their own admission that have gone from the sheriff's detention center to the detectives involved in this case by their own admission.
Where in the affidavits does it show that these recorded phone calls were shared with the prosecutor in the sheriff's office?
Okay, so my representation to the court regarding after the initial bond hearing, when I was told that there were recordings that were done.
And that they were given to the prosecutor and the detectives?
It's my understanding that they are transferred, I don't know if given would be the appropriate word, they're somehow transferred from and this will have to come forward in the discovery and subpoena process, somehow they're transferred from the detention center to the prosecutor's office, because the prosecutor's office is the one that relayed to me that they had them, they discovered what they were, and they deleted them. So again, we have our outstanding discovery and subpoenas. I have to totally rely on what they're telling me here, that what we do know is that these recordings went to Lieutenant Ball, and that Lieutenant Ball listened to them until he figured out what they were, and then allegedly cut them off. Now, interesting enough, in Lieutenant Ball's, in prosecution's affidavit with the case, they make reference to, they make reference to another detective. Listen to the recordings. The issue I have with that, again, is very similar to Deputy Wilmore's affidavit. Why don't we have the affidavit of that person? Why isn't that person identified today? Is there an issue with maybe they don't want to file an affidavit? Is it an issue of they don't want to identify that person? There's no reason for these people not to have affidavits on the record when we're dealing with something that is this major on a case of this magnitude.
Did you subpoena today's hearing or ask for affidavits from anyone?
I'm sorry, Your Honor, I didn't hear you.
Did you subpoena anyone to testify today or ask for their affidavits?
No, Your Honor, because remember, I just got these affidavits and this briefing yesterday.
But you're telling me that Mr. Wood told you 2 months ago that these phone calls had been recorded.
No, that they had some recorded and that they deleted them. And then I filed my motion to amend the bond because of the new evidence that had come to light. And again, in my attempt was not to inflame the situation, but when it happens a second or a third or a fourth or however many times we don't know the answer to that yet, I don't have a choice. I'm in a position now where I have to put things in a pleading that protects my client and discuss the situation we have, because the defense is now compromised to a certain point as far as how I can communicate with my client in preparation for a preliminary, for a trial, discovery responses, defenses, all of these things that go with it. If we go, and if you could give me a second here, Your Honor. The last affidavit that was filed was the affidavit of the prosecution in this case. Obviously, we have issues and limitations in responding as they were filed the night before. In paragraph 2B, the prosecution makes reference that it's never been the practice of Madison County Jail to record conversations between inmates and legal counsel. Again, this is another opportunity since the admission of the recordings to bring forward that information to the court. Instead, they take the opposite. They attempt to take the high road and say, we don't have a history of doing this, when I know for a fact in this case They have. And they can't blame it on COVID-19. They can't blame it on a procedure after COVID-19 because it happened well before then. We then move on to paragraph 2C. Again, instead of owning the violations, they try to blame it on me, and they try to call into question my declaration to the court because of my representation of somewhere between 3:30 and 3:31, I believe that we were recorded. Now, I never had the recordings. I don't have the call log. I have my gut as an attorney that I think this is happening, and it's a problem, and it's happening again. And so I think I have, again, a problem with that. When you go to paragraph EI, again, calling into credibility, even though the recordings are not in dispute. I'm accused of making false assertions to the court. I guess because I didn't present an argument for COVID-19 to justify the recordings. I don't quite understand that, but again, that's what's happening. And that's also illustrated in paragraph 4, that I don't bring that forward to the court. But we also have an issue with the prosecution not bringing forward the previous recordings. So then you move on to paragraph 5. Again, they have unnamed persons listening to the recordings, much like the affidavit of Wilmore. We're relying on hearsay statements that are unnecessary. It's not like these detectives that they're referencing or these other deputies have disappeared, and there's no statements in the pleadings that say we were unable to get Corporal so-and-so or this other detective. In fact, they specifically don't identify this other detective that they make reference to. Then we got paragraph 6 through 10, again, state accusing me due to the 330 or 331, as if they make a comment in there, as if I know how to turn off the recordings, as if there's a button in the public visiting room to turn off the recordings. When I went in on
I think the affidavits are clear that what they're saying is that the deputies told you that they could turn the recording off for you and that you could ask them to do that. There's nothing in there about you doing it yourself, merely that you could ask someone to do it.
And as I represented to the court, the first morning I was there, I was instructed that it had become an attorney-client visitation room only, and that the recordings were turned off, and they were going to remain off, yes.
I understand that clearly. I understand what you're saying there, but you keep saying it's as if I had a button or something to turn off when their affidavits clearly are not saying anything like that. They're saying that you knew you had to ask. Now, I understand that you're disputing that, but it makes it really hard for me to sort through your arguments when you're saying things that aren't really supported by the affidavit.
Sure. I guess the way I read the turn the recordings off, it's almost as if I'm blamed each time that I come in there if I'm not demanding that the recordings are being turned off.
Well, clearly they're saying that if they are recording, there's a warning on there that it's recording and that you should know that it's recording when it says it's being recorded. So that's what they're saying. I understand that you're saying, well, you haven't said it explicitly, but I assume what you're saying is that they're recording even when that says it's on there, and that they're recording even when that warning's not on there.
Sure.
But your arguments are kind of overstating the affidavit, so it makes it hard for me to understand exactly what you're saying.
Well, and I think part of the problem, Your Honor, is getting these affidavits yesterday, the amount of affidavits, the amount of information. We don't really have an opportunity, and I don't think necessarily that we need to have our arguments as organized as we would like, given the time constraints in representing today. There's no way that we are going to continue this hearing, given the difficulties that we've had with the court and the COVID-19 in scheduling this hearing, moving it as a result of what was filed yesterday. I would have loved additional time to serve additional discovery. I would have loved to have gotten a response from the Sheriff's Department on our subpoena as to how this all happened, what was recorded, and these type of things. I think there is another step, and then we can move on to bond considerations. You have a modus operandi here. After the recording, or after the initial bond hearing, there's an admission of recordings. Then there's an admission that they're deleted, right? And that's the conversation we had. that was never brought to the attention of the court except by me. I would have liked to not have been in that position, but I have no choice in representing my client to bring that. We then have statements in compliance, in an attempt to comply with the requirements of a COVID-19 situation where I'm told I'm not recorded, but I am recorded. These recordings are passed on to various individuals, and then they're deleted.
Okay, that's the other statement I'm having trouble following, that you keep saying that the recordings are passed on to people.
Okay.
And I don't see any evidence either in your filings or even what you're saying that the recordings themselves are being passed along, but that information that recordings may have been made is being passed along. So I'm trying to figure out, I'm trying to understand exactly what it is that you're saying. Are you saying that the actual recorded phone calls between you and your client were recorded in some fashion and then passed on to detectives and the prosecution without your knowledge? Or are you saying that the fact that they were recorded was passed on to the prosecutors and the detectives? Because those are two very different things.
You're exactly right, it's the former. And I don't know the exact phrase that would be used because we're looking at our discovery is not responded to and our subpoena. When I get our discovery back that describes how the Madison County Detention Center records their conversations and how, I'm using a general term, how they are transferred through inter-network communication between the sheriff's department, the detention center, the prosecution office, and the detectives, I don't know the exact phrase to use because we don't have that procedure down as of yet. What we do know by the affidavits that were filed is that there have been multiple recordings that somehow, we'll figure this out, these recordings,
From the affidavits filed, you know, there were two recorded.
well, at least two. Rob makes reference to another one, and then we also make reference to the ones after the initial bond hearing. So how many?
Make reference to those, but not in affidavits, just in your argument today, correct? So your
Well-
representation, your proffer, I guess?
If that is denied as being factual, that there was a disclosure to me of previous recordings of my client that somehow made their way to the prosecution office and deleted, we have a much bigger issue on our hands. Then,
You're proffering that on a certain date between the last detention, or the last bond hearing and your filing of the motion, that Mr. Wood told you that there had been jail recordings of your conversations with your client that had been deleted.
I don't recall the use of the word jail, but it was between me and my client. So if I'm trying to be exact for the court, the admission was there had been communications between me and my client that were recorded. Somehow he became aware of them and they were deleted. I do not know how many as of yet. I do not know who else had access to them. I do not know who listened to them. What I do know is that prior to the COVID-19 pandemic and the changes at the Madison Detention Center, recordings were made and they were, for lack of a better phrase, passed on in some shape or form to the attention of at least the prosecution in this case. Now, how much of it was listened to, who determined that it was our recordings, I don't know the answer to that yet, Your Honor, because we don't have the discovery and the subpoena responses yet. I'm hoping that comes over. The bigger concern for me.
Okay, well, let me stop you there too, because I don't know for sure about Madison County, but I know that Bonneville County Jail, which I think uses the same system, there are any number of people who can access the recordings from their computers. So they can just log into their computers and see what, Joe Jones is saying to the wife that there's a no contact order with. And so they regularly, probation officers, police officers, detectives, prosecutors, look for jail recordings. This is a very common practice. They can access them. There's no actual recording. It's a computer method of getting them.
And that could very well be true in this case here. It could be as simple as there was a recording and Lieutenant Ball said, oh, there's a recording here of Lloyd Vallow, or there's a recording from yesterday, and he clicks on it and he listens to it. Or there could be a mechanism that automatically transfers specifically her recordings or her communications to somebody else. I don't know the answer to that. What we do know is that there have been more than at least 3 recordings admitted and deleted. Now, I've got another problem with how this plays out, because you have an issue where there are recordings that are statements of my client. I have outstanding discovery, not talking about these recordings discovery and the subpoena that goes with that. I have outstanding discovery requesting a copy of all statements of my client, whether they're recorded, whether they're typed, whether text messages, whatever. You cannot say that these recordings that are created through some kind of process at the Madison Detention Center are not statements of my client, so I would argue, subject to the discovery request.
That's going far outside this. I mean, certainly you're entitled to any statements made by your client that have been made on jail phone calls.
Sure.
Certainly, that's clear.
Sure.
Let me go back to your affidavit too, because you're making a lot of really serious representations that are not included in your, you called it a declaration. I think the rule requires affidavits, but it's, your declaration is under sworn penalty of perjury. But I don't see anything there saying that there have been, between the first hearing and your motion of April 2nd, Mr. Wood admitting that there had been previous occasions that they had been recorded.
Your Honor, and this is where I think I struggle. This is where I'm not a fan of what I would call ambush litigation. I'm not a fan of grandstanding. I'm not a fan of melodrama or attracting unneeded attention. When I filed my initial motion with the court back in March, I alleged new facts have come to light. With that motion, I've known the prosecution in this case for quite some time, and it was my hope that they would bring it to the court and explain it to the court so that I didn't have to. That was not done. And in fact, the opposite happened, where now I'm in their filings from last night being accused of misrepresenting or withholding things from the court. It obviously is an issue that it was not brought to the attention of the court so that the court could make a decision today based on all the information that is available. And like I said, if it is denied, we have a bigger issue.
Well, I completely agree with you that I need to make a decision based on all the information I have available. But the only information I rely on is either testimony or sworn affidavits. And so you're here in court today telling me all these things that you argue are true, but you didn't include them in an affidavit at any point in time. And I understand that what you're saying is, well, I didn't want to make Mr. Wood look bad. But it's just hard for me to reconcile the fact that you submitted a sworn affidavit where you had every opportunity to lay out these allegations that happened in March before you filed a second motion for bond reduction. And you didn't take that opportunity, and so it makes it difficult for me to make a decision because I cannot use as evidence your statements in argument of what might have been said.
Your Honor, if I think this goes back to the very beginning. If my motion can be interpreted to be an additional opportunity to present evidence to this court without prior notice, I don't think that sword can swing toward me in that way and say, you can't make this argument. I mean, from the very beginning.
Well, you can make any argument you want, but when you ask me to rely on facts, then I need to rely on facts that are before me in some fashion. Now, if you were to make a proffer of exactly what date and what admissions Mr. Wood said as a member of the bar and those ethical responsibilities, then I might be able to go forward on that. But it's been hard for me to sort out exactly what your accusations are.
Right. Well, the situation that I get into is, would the court want me to call Prosecutor Rob Wood to the stand to discuss this conversation?
Well, if I get the chance to hear from Mr. Wood, I'll hear what he has to say about those other conversations.
Yeah, and that's how I'm hoping it can be resolved. Again, because I don't want to have to take it further than we need to. But what we have here is repeated violations, prior COVID-19, post-COVID-19, that have made it to where I cannot, in good faith, communicate with my client through a telephonic system at the Madison Detention Center in preparation for what is probably one of the largest cases to ever come through Madison County. And the amount of documents and other information, we're dealing with things, in this case now, with this recordings, that we should not be dealing with. But unfortunately, we are. So, obviously, Your Honor, I'll save any other additional remarks unless you have questions for me regarding after you have an opportunity to discuss the situation with the prosecutor. If you would like, I could go ahead and move on to what we would like to happen as far as the bond goes, what we would like the court to do.
I mean, I've allowed
Sure.
it well over an hour so far.
Sure.
We only have another hour and a half left. Mr. Woods needs to respond, and then I'll give you the last word since it's your motion.
I appreciate it, Your Honor. If you could give me 1 second here. I believe it's Rule 46 of the Idaho Criminal Rules that discuss the factors to consider when setting.
Let me stop you there, because at the beginning, I said I was not asked in your motion to reconsider Judge Eden's decision.
Okay.
I'm being asked to reduce bond after a decision on bond has been made at previous hearing.
Sure.
And under 46L, I think it's 46, L2, then the standard that I'm applying is good cause to reduce bail.
Sure.
So I am not at all inclined to revisit Judge Eden's decision where he went through all the bail factors in Rule 46 and in the statutes. That's already been done.
Correct, Your
So
Honor. Correct.
you said there was new information, and the second bail hearing, I'll go forward on good cause, and that will be the standard. So there's no need to go through all the factors that Judge Eden's decided.
Appreciate it, Your Honor, because that is basically a regurgitation of those factors, so I appreciate it. As far as what's happened since the hearing, I don't think I need to spend a lot of time to talk about the effects of COVID-19 on everybody and now the limitations on interacting with my client through the detention center. I think you also have to look at and consider the economic situation that we're in now, where jobs are difficult, people are not spending money. My client is obviously unemployed at this time. Her husband is a publisher. People aren't buying books. There's a difficulty all the way around when it comes to paying rent, paying mortgages, getting jobs, these type of things. I think that needs to be taken into consideration when it comes to setting up a bond amount. COVID-19, as I've illustrated before, I don't think can be a good cause argument as to why the Constitution or these type of things can happen to limit the interactions. I think also the thing that the court should consider is the Supreme Court and their order on April 22nd, 2020, where they say the postponement of criminal jury trials required by this order shall be considered among the factors listed under Criminal Rule 46, determining amount of bail and the purpose for determining eligibility for pretrial release. Even though that is making reference to a jury trial here, as we know just from this case here, we've had to push it off multiple times. Just from the scheduling conference yesterday, the preliminary hearing, instead of occurring in a shorter time frame, is going to be occurred in July. So hopefully we don't have these COVID-19 issues. I think the spirit of the order from the Supreme Court would ask this court to take that into consideration in setting the bond amount here.
But this trial isn't being delayed because of the COVID situation.
Well,
We haven't got to preliminary hearing, and it was delayed until July on your motion, not on the state's motion.
Yeah.
And we don't get a trial date until it's bound over in preliminary hearing. If that happens, district court is the one that would set the trial date. So that hasn't even happened and won't happen until after July.
Correct, Your Honor. But if we're also talking about the scheduling conference yesterday, my initial suggestion was to do it in the 1st of June. There's obviously the court, as we mentioned, for Rob, myself, and for you, all of these cases that have been postponed and pushed out and rescheduled are eventually going to come to call. And that's where we run into a situation where maybe in a typical situation with her preliminary hearing, it would be able to be heard in the 2nd or 3rd or 4th week of May or the 1st week of June, but now it can't.
My schedule allows that to happen. If you want to have the preliminary hearing in May or June, we can do that. Yesterday, the conversation was, as I understand, that you preferred a different date so that we wouldn't all have to appear in masks at the preliminary hearing, but my schedule certainly allows for it to happen in May or June.
Sure. My initial response, when requested, or when asked about availability, was the 1st of June. I wasn't so much thinking one way or the other regarding the mask. If it needs to happen, it needs to happen. It's obviously difficult to breathe. It would be a long 2 days to go through that process if we have to wear them. But I would prefer in June and instead of July, but it was my understanding that it seemed to work better for the court schedule if we did it in July, and maybe I misunderstood that.
That is a misunderstanding. If you would like a June preliminary hearing date, I am more than happy to accommodate that. If I'm assuming Mr. Wood would be able to accommodate that as well, since he was prepared to proceed next week.
Sure. Okay, and maybe that's something that we revisit today or in the near future if we need to. My position was with the Supreme Court order, even though it only referenced the jury trial and pretrial release issues, I think the spirit of it is if a preliminary or these type of hearings are continually pushed out, then we have an issue. I mean, the recordings that we're talking about, we're the 1st of April and the end of March, and we're a month later as a result of COVID-19. We could have had this conversation 30 days ago, but by no fault of anyone in here, it gets pushed out until May 1st. Those are the type of things that I think the court should take into consideration in setting.
We did have an informal conference 3-4 weeks ago where we had a jail representative here, you were here, Mr. Wood was here, and I tried then to make sure you knew who to talk to at the jail and that we smoothed out any wrinkles.
Well, I had a problem. I really appreciate, and I want to make this clear, I really appreciate the court in this unique situation that we're in, conducting those types of communications, because I always believe that if attorneys are talking to each other, if they're shaking hands, even if they don't really care for each other, justice can be better served. It can be served in a more efficient manner, and it can be done in a better manner. And so I appreciate that. But in reference to that,
it's important to me that you have access to your client as soon as possible, knowing that the jail had to protect their inmates from
Right.
COVID-19.
Yes.
So there were unusual circumstances, but I also wanted to make sure you had access to your client and that the jail knew that I was involved in that process.
Sure, and I think the difficulty that I got into in that hearing is, one, it was noticed on a very short amount of time as far as notice goes. And again, I appreciate the court doing that. That's the world that we live in right now. The response and the objection to my motion was filed, as I said earlier, about give or take 2 hours before that hearing, only after we were requested to participate in that hearing. And I made it clear at that hearing that I did not have authorization to discuss that motion or to move forward or to talk about possible resolutions of my motion without.
I wasn't talking about resolution of the motion at all. I knew it would take some time to get the motion heard, and I wanted to do all I could to make sure you had access to your client before we could get the motion heard. So I was not asking for any resolution, or I don't want to leave the impression that I was trying to promote resolution of that motion at all. I did not expect you and Mr. Wood to do that at all. All I wanted, my sole purpose in that status conference was to make sure that you and the jail were communicating with each other and that we were taking the appropriate steps to know what was going on with the virus in the jail. At that point, it was a very dynamic situation at the jail. So I just want to make that clear for the record that all I was intending there was to smooth your access to your client.
And I appreciate that. And I think that occurred on the 7th of April. I think at that time, and somewhere in here, the motion was set to be heard, I believe, on the 14th of April at that time, and then it got moved. And so what we were talking about is a week time frame there, but not an opportunity to really openly discuss some of the concerns that I had as far as access or communication with my client. I wasn't able in that informal setting, Your Honor, to discuss the idea of the recordings and how they happened and how we're going to fix them.
I would not have expected that.
Exactly. And that was the situation that I got, especially without my client present or without my client having notice of the hearing. So, Your Honor, we would ask that the court would take all of this into consideration. I want to make it very clear in I haven't been doing this as long as a lot of people, but I've been doing it a while. I have never seen a situation like this where I feel, based on what has happened pre and post COVID-19, that I cannot have why my client is detained in the Madison Detention Center, confidential communications as we sit, especially now, and even before COVID-19 when they were recorded. I cannot take her case, prepare a defense in a case of this magnitude with the limitations and the idea that potentially it's being recorded and or in some way or another making its way to various individuals. That's a problem that we have. I think the court, in taking that into consideration, looking at the COVID process, looking at the economic downturn, looking at that my client is not an economic or a rich woman, taking into consideration and setting a bond that is reasonable and something that she could meet, and at the same time keep enough skin in the game where where the court feels comfortable in allowing her to put this bond amount down and be released to her husband so that she can better help me in preparing her defense.
Thank you, Your Honor. Couple of issues. An affidavit of an officer, especially on a bond hearing, hearsay is allowed. Is allowed. I want to talk about this issue that all these phone calls have been recorded. Usually, when an attorney takes on a criminal client, in this area, it's usually the same attorneys. The jail has their numbers on record. When they call in with that number, that call is always confidential. At the beginning of this case, I think what Mr. Means is referring to, well, before I go there, because I don't know that here's how this works. The jail actually doesn't record the phone calls. Telmate records the phone calls. Different people have access to Telmate. The jailers have access to Telmate. They can't alter anything from Telmate. In fact, and I need to correct, nothing is actually deleted, but it can be blocked. So if a phone call is ever made, it can be blocked, but it can't be deleted. And that's something I've learned through this process. Now, if an attorney doesn't register their number with Telmate and an inmate sends an outgoing call to that attorney, it's not going to be protected. And the thing to remember, though, not only is it not going to be protected, they will be warned, because every non-confidential phone call starts with the warning that these calls are subject to monitoring and recording. Case law is clear that when you know someone else is listening, it's not a privileged conversation. We've submitted that in our brief, and it's clear. So this issue of multiple phone calls. The first time Mr. Means came into my office, he met with me and Spencer Rammel. I had, I believe it was that day, heard his voice. One of our secretaries who are allowed to listen to jail phone calls had that phone call going. I said, stop that phone call. We called Jared Wilmore, Lieutenant Wilmore. He blocked it. We said, block this number, because it was the same number I had. Deputy Wilmore can verify that. When Mr. Means came into my office and he met with me and my deputy, Spencer Rammel, we let him know about that. And we said, hey, make sure you register your phone. This idea that we told him that multiple phone calls were being recorded is absolutely false. And Your Honor, we are more than happy to allow Mr. Means to come over and get those phone calls. And he can see that multiple phone calls between him and his client have not been recorded. I do want to talk, though, now about the specific issue at hand, which is the alleged phone calls on the 30th and 31st. Before I get there, though, I would like to make note that if you file a pleading asking for a bail reduction saying new facts have come to light, I don't know if he expected me to decipher what that meant, especially when we had already talked to him about that one phone call. You can't expect anyone to respond to a vague reference to new facts have come to light. Quite frankly, we don't know that that's what that meant, because he didn't plead it in particularity. So I want to talk about this new claim that bail should be reduced because of March 30th and March 31st. Your Honor, when I sat down with Deputy Wilmore, or Lieutenant Wilmore this week to further prepare for this hearing, this declaration can only be read in one way. It can only be read in one way. And so let's talk about what's in it. Clearly, he knows he's being recorded, because he says in paragraph 5 that upon arriving at said detention center, I was required with no attorney-client option to the sole option of communicating with my client in the public visitor meeting room, wall of glass between attorney and client, over a recorded telephone line, upon which my client was required to enter her inmate number for charges and consent to recording of said phone call prior to the connection of the telephone lines. Your Honor, the problem the state has is, don't rely on what I say. Don't even rely on the affidavit. Rely on the records that were provided to the court. There was no recorded phone call on March 30th. Deputy Wilmore, and it shows in his exhibit C and D, turned it off for 24 hours that day. Now, and then on the 31st, they do have these recorded phone calls. Again, which I guess I don't quite understand what defense is arguing, because he said he had a hunch, but in paragraph 5, he makes it clear he knew a call was being recorded. Not only that, every recorded phone call on Telmate starts with that warning. These calls are subject to monitoring and recording. And so the problem is they're now saying this is good cause for a bail reduction. I don't think that's the case at all. I think this is an attempt to divert the court and the public from the actual facts of the case, to deal with the actual case. It's a way to try and get the client out on an issue that doesn't exist. And here's the thing. When an attorney and the defendant hear this call is subject to monitoring and recording, it's no longer privileged. They can't claim privilege. Case law is clear on that. They know that a third party could be listening. And the problem the state has with this document is that it's clear that on the 30th, and the records support this, that phone call was not recorded when they'd asked for it not to be. So, and I want to point out the affidavit of Ron Ball, who, by the way, is completely authorized to listen to jail phone calls. He hears a phone call. It's a male voice he doesn't recognize, and he doesn't announce his name, which makes sense because he's just sitting across from a glass wall from his client. He hears some things about court.